Appeals, Division 1, is now in session.
Thank you. You may be seated. We are here today on our case number 1CA CV160127, Harding versus sternsher. Excuse me. We are grateful to Judge Polk for sitting with us on this calendar. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it because the clock on the podium will reflect the total amount you have left, including what you may have decided to reserve. When you approach the podium, we'd be grateful to each of you if you would give us your name and the name of your client, because we record these proceedings and it helps us keep track of who's who. We have read the briefs and we've studied the record at considerable length. We've also discussed the case in our conference. So with that, you may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. Thank you for taking the time out to hear the oral argument today. It's a very important one. My name is Carmen Chanel, and I'm here for my client, Dr. Harding, and his wife, Julie Harding. I will want to reserve 5 minutes for rebuttal. Your Honor, the procedure on this case, and I know that you've read everything, is that plaintiff filed a motion for summary judgment. And what happened in that motion was we lost the intentional and negligent infliction of emotional distress claims and the conversion claim. What remained for trial was the defamation claim against defendant Dr. David Sternsher and interference with business expectancies and a counterclaim from the defendant on breach of contract. We believe that it was a clear abuse of discretion of the trial court to exclude the 101 pages of transcripts that showed that defendant had actual malice when he published on the web 22 different postings that were so abusive and so many lies regarding my client that it was amazing. He posted such things as my client, Dr. Harding, who had an impeccable record up until that point in time and absolutely no postings that were negative, that he abused the kids, that he and the doctors in his office put fingers down their throats, that they tied the kids up in papoose, and if they were crying or screaming, they let them cry and scream. I mean, it was just really horrendous postings. We believe that the transcript of the recordings, the audio recordings of Dr. Sternsher, clearly shows that he did those postings and that he intended to do them, and he wanted to not only put my client out of business, but put him in jail for Medicaid fraud.
May I ask you a couple of questions about the record? You noted that you thought that it was error for the Superior Court to exclude admissions of the transcript of the recording. Were you seeking at trial, or was your client seeking at trial, to admit the recordings or to have the jury listen to the recordings as part of the trial evidence during trial, or were you actually seeking to admit the transcripts?
Your Honor, I didn't do the trial, but in the trial court, my understanding is that they wanted the transcripts, the 100-page certified transcripts admitted in evidence, as well as the audios.
So it would have been the audios, at least in addition. Then let me ask you a different question. Assume for the moment that we agree that the court's exclusion of the audio or the transcripts, well, I'm going to use the word audio, and that you can assume that that includes the transcripts, the audio recordings, was error. That they were relevant, they were sufficiently designated to be clear, and so forth. How then, however, was your client really prejudiced? Because if our case law instructs us that if there is a mistake in either the admission or the exclusion of trial evidence, nevertheless, the exclusion or the admission has to be prejudicial. And given that trial counsel for Dr. Harding was allowed to impeach the defendant using those transcripts, and so the jury heard a lot of evidence that was, or information that was in the transcript, how were you then really prejudiced?
Your Honor, the impeachment was very limited, and I have here 1.5 pages of the transcript of the impeachment on the cross-examination by counsel for my client, Dr. Harding. 1.5 pages of 101 pages of transcripts is not sufficient to show the malice of the defendant, that he really wanted to put this man in jail.
Is the prejudice then, is your point about prejudice simply limited to quantity?
Well, the parts that were omitted were very critical to show the malice and the intent.
I've read the transcripts of the recording, all of them. And I have read most of the trial testimony, including the Dr. Harding's direct and cross-examination. And it did not strike me that only snippets were used as impeachment, but that it came through loud and clear about the defendant's comments to Mr. Felix Lucero. That dialogue came through. So I'm not if your basis for the prejudice is simply on quantity, then I'm not sure you're persuading me.
Your Honor, there were snippets of the cross-examination that dealt with the transcript, and in fact, my client was not even allowed to say that they were the recordings of Dr. Sternsher. So the jury was left with, statements such as, isn't it true, Dr. Sternsher, that you wanted to put my client in jail, yes or no? But they weren't allowed to say what the source of those statements were, that they came from these audio recordings. And I think that is really critical, because it was confusing to the jury as to where those statements came from and what was their relevance to the case.
Why was it confusing? Why didn't the jury understand the relevance to the case of the statements when they were used to impeach Sternsher?
Your Honor, because plaintiff's attorney at the time was not allowed to say these were recordings, audio recordings of defendant that showed that he intended to do these postings, that he intended to put the client out of business. It was excerpts. The cross-examination was very short on those issues, and the judge did not allow the plaintiff's counsel to clearly state on the record, these are audio recordings. These are audio recordings of defendant which show actual malice, which, Your Honor, without those transcripts, without those audios, our case was totally, the heart of the case was cut out. And it was cut out at the very beginning of the trial, because that motion for summary judgment, in fact, and the court records show this, malice was left as an issue for trial. So how are you going to be able to prove malice? How are you going to be able to prove the thought process, the intent of the individual that defamed my client without admitting those audios? And clearly, if they had been admitted, and if Felix Lucero, who taped the defendant, was asked about them, which he wasn't allowed to ask him about them, it would be clear, crystal clear to the jury that defendant absolutely intended to defame my client and acted with malice that was just incredible. I mean, he wanted to put him in jail.
Well, didn't the jury hear actually that Sternsher approached Lucero or someone else, I'm not remembering, in the office and asked him to steal medical records so that Sternsher could make up a complaint to be filed against Dr. Harding?
Well, that's very slight compared to the rest of the audios.
They did hear that.
I think they did, Your Honor.
So the jury knew that Sternsher was held enough malice to want to induce an employee of Dr. Harding to commit theft and assist him in a fraud.
Correct. Yes, that's correct, Your Honor. But obviously the jury wasn't convinced that that was enough to build the element of malice. If they had heard all the rest of the audio, they would have it would have been so crystal clear to them that I believe that plaintiff's counsel could have won on a directed verdict.
Is it possible that the jury just concluded that Dr. Harding didn't make the postings? I'm sorry, Dr. Sternsher didn't make the postings?
I find that difficult to believe because I actually took the deposition of Dr. Sternsher, and the postings had misspellings. I asked Dr. Sternsher to spell certain words at the deposition, and they were misspelled exactly the same. So I believe that they thought that he did those postings, but that the intent, the malice, wasn't there to substantiate a defamation claim. And I think that that whole issue of malice was critical to the case. And without really diving into the audios and going through them methodically, my client his case was cut at the heart. There was no way to show the intent of this defendant.
I wonder how we can know that the jury, by your account, must have found that the postings were false.
Your Honor, I can't answer that question.
If the jury did find that they were false, and that's your point, wouldn't someone have to despise another to make up stuff like that online?
Exactly, Your Honor. He despised him, and he even said it in the audios. I despise this man. I want him, to be out of business. I want him to go to jail.
But your theory, or your client's theory at trial, was that Dr. Sternsher made up horrible things and posted them online. You're telling us that the jury found that, yes, Dr. Sternsher did make them up out of whole cloth, horrible things, and post them online, but didn't find for your client because it didn't find that Mr. Sternsher did it, Dr. Sternsher did it with the requisite intent.
I don't know what the thought process was of the jurors as to whether or not they thought that those postings were done by Dr. Sternsher, or whether they thought that somebody else did those postings. I can't answer that question. That goes to the thought process of the jurors, and that is not clear to me one way or the other. What is clear to me is that if the audios had been presented in evidence, that absolutely the jury would not doubt for 1 minute that, number one, those postings were done by Dr. Sternsher, and number two, that they were done with malice. Taking all of the evidence together, they would have come to that conclusion. By not having the ability to present all these recordings, there was no case. You couldn't prove the malice. How could you prove it?
Well, I've suggested a way, just by, as I said, the theory of Dr. Harding's case was that the postings were false. To post false postings like that, I would submit malice is implied in just the fact of doing that, but that's a trial strategy. Well, one of the defendant's arguments is that it was unfair, that the recordings were unfair. And, is it unfair to use defendant's own words before a jury? To listen to the recording, and those are the recordings of the defendants, why would that be unfair? And another argument was that the recordings were confusing and out of context. And let's reverse that argument, because in fact, what he was arguing was that, this is in his brief, in his answering brief, the appellee is arguing that it was unfair because these recordings were taken out of context. Well, defendant's counsel at the time could have filled in the context, but let's reverse that idea. Okay, the limited recordings that plaintiff's counsel at the time of the trial was allowed to ask questions about, they were taken out of context. They were very limited. They were taken out of context, and that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not be able to produce the recordings. And that was unfair to my client to not
the entire audio recordings so that the jury could actually see the malicious intent of this client, of the defendant. I just don't know how malice could have been proven without those recordings.
Let me, and I do understand your point, but I'm still troubled by the prejudice issue. For example, in looking at the trial transcript from October the 21st of page 45, after plaintiff's counsel obtained permission to use the, for impeachment, the question is at line 7, Dr. Sternsher, in July, I'll leave out the profanity. In July of 2013, you recorded telling Felix Lucero, so there's a recording, there's a date, that if I can somehow bury him, then I can tell you. Obviously, I would be certain that I would be very, very busy and need a bigger place, et cetera, weren't you? Answer, this is Dr. Sternsher. If you read that, then I said that during the hours of conversation with Felix, yes. Question, by somehow bury him, you meant Lee Harding, didn't you? Answer, yes. That's pretty powerful evidence of real malice.
But it's not. It wasn't enough to find it.
Well,
I mean, you might.
But there
think,
comes a point when evidence becomes cumulative. I've looked at the recordings. There's a lot of that. At some point, the jury is probably going to say, you know, we've heard this enough. We know how Dr. Sternsher feels about Dr. Harding. We don't need to be beaten over the head with a log or a post, as the case may be. And I've just read a few lines. There's other information in the transcript. So again, it just strikes me, and I'm struggling with this issue. That's why I wanted to surface it for you about how we can say, as an appellate court, the exclusion from the plaintiff's case in chief was prejudicial.
I think that, for one thing, it's just a page and a half of cross-examination, a page and a half as opposed to 101 pages. I think that if you go through the audios and through the transcripts, you find a pattern that you can't avoid. It's not that the plaintiff's counsel would have gone through every page of this, but he could have started there were 3 different meetings at the first meeting, what that pattern was, how his mind worked as to, I mean, he, even in here, he talks about himself as being a criminal and that he hopes, you know, he doesn't end up being in trouble. But I think that the difference between a page and a half, it's a page and a half of cross-examination on 101 pages of transcripts is not sufficient to show that pattern from the very beginning to the very end, from the time that, you know, he met with Mr. Lucero, and Mr. Lucero was the manager of the office at the time until the very end. And that pattern, you could just see what he was doing. This is, I'm going to file a complaint with Phoenix Health Plan. I'm going to go to Access. I'm going to do this. I'm going to do that. We're going to bury him. When you read the transcript, you get the feeling of the pattern of the intent of the malice. You don't get that from a page and a half of cross-examination. And I do believe, Your Honor, that
Did you want to reserve time?
I lost my time. I'll use my time up here. Is that all right, Your Honors?
Absolutely. I'm sorry for interrupting you.
No. Thank you very much. You know, I do believe, like I cited the case of State versus Salamanca. It's a Court of Appeals case from 2013, and in that case, actually. The appellate court said that it was fine for the trial court to show text messages that were occurring while an individual was driving to show his malice, to show his intent, and then he killed someone. And in that case, I thought that it was really poignant. The trial court talked about all harmful evidence is unfairly prejudicial, correct? Any harmful evidence that you have is going to be prejudicial to the opposing side. And then it goes on. In that case, the trial court talked about all harmful evidence is unfairly prejudicial evidence, which is relevant and material and will generally be adverse to the opponent of the party, often offering it in that sense prejudicial. it talked about in detail about that kind of formal prejudice is not the basis of exclusion of that evidence under Rule 403. So what we're arguing here is Rule 403, and Rule 403 says that if it's more probative than prejudicial, you should allow it. And in this case, it was the heart of the case. It was everything that the case was about. It was malice and intent, defamation. Period. I mean, how can you possibly show the malice without showing that pattern throughout those 3 meetings and all that occurred? And I don't believe that a page and a half of cross-examination was enough to sink into the jurors' minds, hey, this guy is really awful. This guy acted with malice. Without listening to major excerpts of it, they couldn't have possibly concluded that he had malice. I have 54 seconds left.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Michael Garrity of the law firm of Israel and Garrity on behalf of the appellee, Dr. David Sternsher. Thank you for taking your time for oral argument this afternoon. Appellee's position in this case is essentially that appellant has a heavy burden placed upon them. Appellants, it's actually appellants. The doctor's office is one of the appellants. They have to demonstrate not only an abuse of discretion, but as Judge Norris, you suggested, they have to prove that prejudice flowed from the abuse of discretion. And there are 3 buckets of problems with appellant's arguments. The first large bucket, and 2 buckets apply to the issue of the exclusion of evidence, and the third bucket applies to this issue of the denial or the granting of the motions for summary judgment. The first bucket of problematic material for appellants is the fact that's been alluded to, that the bulk of the damaging portions of these transcripts was actually admitted. The jury got to hear it. It's hard to argue that there's any damage when they got to hear the tastiest, most damaging slices of that pie. And counsel argued that 101 pages of transcripts were excluded, but you've read the transcripts. That there's 15-some pages of appellant Dr. Harding coaching his witness on what to say and what to ask before Mr. Lucero went in to talk to Dr. Sternsher. And I might note that then Mr. Lucero got up on the stand and claimed he was never coached. But there are 15 pages of him being coached. So he had huge credibility problems. And that part of the transcripts doesn't help appellants. And yet that's part of the part that was kept out. In fact, I didn't get an opportunity to really hammer that point because Mr. Lucero was appearing by telephone from Alaska and simply couldn't appear anymore. He had to go back to his job. So my cross-examination of Mr. Lucero got grossly cut off, and I didn't get to bring home. I asked him the question. I read a slight quote of coaching, but I didn't get to hammer home that there were 15-some pages of him being coached when he had just said under oath that he was not coached. So what we've got is 101 pages with actually 10 or maybe 11 quotes that plaintiff at the trial court, appellant here today, wanted in badly. And those quotes got painted everywhere. They are repeated over and over and over in the briefings. They were repeated over and over and over in every single motion. They were repeated over and over.
But forgive me. We're talking about trial.
I know we are.
We're not talking about motions. We're not talking about briefing. We're talking about what this jury heard. And, I mean, I think this is a difficult issue. You've tried cases. I've tried cases. It's one thing to give a jury a snippet of information a couple times, two or 3 times. It's another thing to have the jury in a party's case in chief hear out of the mouth of the other side what they're saying about your client and how damaging it is. And I mean, I do appreciate there are facts and there are persuasive facts. And I think the argument here is that the power of this evidence was stripped away because it was allowed in only through impeachment, not through direct evidence in the case in chief. and thus it lost impact. And it's a little hard for us to gauge that because we weren't there, but nevertheless, that's the point.
Your Honor, what I was trying to address is the speciousness of the claim that they wanted to get it in 101 pages, because what you will find repeatedly throughout all of their pleadings, in and out, in front of the jury and not, were the fact that there were really 11 quotes they wanted in. They didn't want in 101 pages.
Well, I don't think they do either, but they wanted
They wanted 11
there's a lot
quotes.
of good juicy stuff there that's not contained in the October 21st transcript for basically pages 44, 45, 46, 49, 53, and I think 54. I mean, there's a lot more good stuff there.
There's about 11 quotes they
Yeah,
want in. They
yeah.
got 6 of them in. And if
Okay.
you look at the ones they didn't get in, very repetitive of the ones they did.
Mm-hmm.
It's hard to imagine that would have swung the jury around.
Well, what about the fact that the plaintiff's counsel had to read them, like using a deposition, rather than allowing the jury to have the power of your client's voice?
Well, as you quoted, in each case, he made it crystal clear that he wasn't just reading this. He was reading this from a recorded transcript. And in fact, he said, isn't it true that you were recorded saying, and my client sat there and admitted it each time. Now, if that's not powerful, I'm not sure what is. My client said, if that's what the transcript says, then that is what I said in that conversation. But you have to understand.
Isn't there a difference between hearing the lawyer's inflection and tone of voice versus hearing your client actually say it at the time?
Sure.
Tone makes a difference, doesn't it?
I can concede that point. I don't think that when you look at all of the other problems that appellant had, that this then becomes the crux of it. And as Judge Norris, you alluded to, the Gemstar case does require that they show that it actually prejudiced them. And I can, when I get to bucket number 2, I'm going to give you an awful lot of other reasons why the jury didn't find in their favor. It has nothing to do with not getting to hear repetitive additional quotes in my client's own tongue.
Before we get to the second bucket, what's the best argument you can make in support of what the trial court did in excluding the evidence from the case in chief?
Okay, the best argument is that none of the quotes, nothing at all directly proves an element of appellant's case. It is suggestive of a state of mind, but there's an alternative explanation for his state of mind, which is that my client was extremely emotional over what he perceived to be terrible, terrible abuse of children, paid for by the state. This got him very bothered and very emotional, and therefore there was another reason that he was this emotional, not malice, but wanting justice. The court specifically cited that in a list. The judge actually stated something along the lines of 7 different reasons why he felt that this was inadmissible material. And one of the big ones was the timing. The timing made the probative value of this extremely questionable, because what we have is statements that were made in June of 2013. But the letter that they're trying to prove the state of mind about was from 6 months before, in December of 2012.
But what about the online postings that
Every
occurred
one
after?
of those. 5 of those were more than a year before the recordings. 18 of them were more than 6 months before the recordings, and all but 2 were well before the recordings. So the judge specifically quoted that fact as being very problematic to him. You're trying to show.
But doesn't that go to the weight of the evidence? I mean, giving your client deference, he may well have had a couple of different motives. One, because he was outraged over the alleged treatment of the children, and one because he really, really, really hated Dr. Harding, had out for him. But how that testimony or how that motive should be assessed by the jury, or which version, that's a jury question.
It is a jury question, but the jury got to hear 5 out of half the statements, and the rest of them would have been merely repetitive.
That's your best argument as to why the judge did not err in excluding the evidence. It strikes me that kind of doesn't help, because that's just that's a decision for the jury to make. Maybe you need to go to the second bucket.
I believe that the probative nature being outweighed by the risk of prejudice is a valid reason for the judge to exclude, and that is, if the probative evidence is brought down by the timing, then that escalates the judge's reason for saying that the prejudicial nature or the potential prejudice does outweigh. So I think I still got a bit of a hope in that bucket. But I will move to bucket number two. Bucket number two is that appellants seem to make the argument, or actually jump to the conclusion, that letting this in suddenly changes the jury verdict, as though this was the crux, the only thing the jury had to work with. And that's abundantly false from pages and pages of trial transcripts. First, there was an issue of prejudice, but I need to make sure that even though it gets raised in the appellant's argument, before trial, the appellant withdrew the portions of their claims that related to my client's formal complaint. And by the way, though, they withdrew those portions of the claim. So there was a formal complaint filed by my client before the dental board, and then he sent a copy of that complaint to the access providers, including PHP, by the way. Now, one of the things that the jury could have concluded is, if we all know that he did a formal complaint, why on earth would he then send an anonymous letter to PHP? He already sent a copy of his formal complaint there. Why would he have sent an anonymous letter? Jury has to ponder over that. And again, the admission of evidence does not equate to a jury verdict here, because we've got this privilege issue. We've got the huge issue of identity. My client readily admits that he filed the dental board complaint, readily admits that he sent copies of that to access providers, including PHP, denies that he ever did any online postings, denies that he ever did any anonymous letter to PHP, and why would he? Because he was already submitting a formal complaint to them. You look into the other evidence that the jury had on that issue. They have the form and format of that letter to PHP, which just so happens to look exactly like the form and format of the letter that Araceli, she had given a letter for my client to add to his dental board complaint. And if you look at the formatting of both the anonymous letter to PHP and the letter that she gave to my client to attach to his complaint, they're identical. I put them up on the screen for the jury to see side by side. And then I flashed over to my client's complaint, and you can see that it is a completely different font, completely different typeset, different style. Everything about it is different. I think that was very powerful evidence for the jury to see that this anonymous letter given to PHP, a place that my client has no good reason to send an anonymous letter when he's sending an open and notorious letter to them, matches the formatting of one of our potential candidates. And that's an important point. We've got literally droves of potential other candidates for doing all these online postings and doing this anonymous letter. The plaintiff, it was very clear at trial, fired people and did so in spectacular fashion, so that people were very unhappy when they left. And in fact, we brought in 7 people to sit and testify as to all the problems that they had when they worked for plaintiff, which brings me to my next reason that the jury could have easily found in favor of my client, regardless of whether they'd been given another 6 unsavory statements from a recording, which is that there's the issue of truthfulness. The jury had before it an issue that there's an affirmative defense to a defamation claim of truthfulness, and we had 7 witnesses come in, and every one of them said the same thing. They didn't all know of all of the aspects, but every one of them said, that's true, that's true, that's true. Then the next person would come in and go, I don't know about that, but that's true, and that's true. And down the line, we had evidence to support a truthfulness defense. So there's another reason that the jury could easily have found in favor of my client that has nothing to do with whether they heard 5 more unsavory statements, repetitive of the ones that they did here. There's also a huge problem that we presented at trial, which was a causal connection between the alleged conduct and the damages that plaintiff claimed. Not to pat myself on the back, but I painted gigantic holes in their damages claim, where they alleged that the reviews matched up contemporaneously with the time of their decline in income. Dr. Sternsher got on the stand and testified as to an alternative basis for why the income had declined. I showed that there was not a nice, clean connection between the income going down and the dates of the reviews. The jury could well have taken many, many issues with an inability of plaintiff to connect the dots between these reviews, even if they decided that my client did them, which he denied, and which there were lots of other people that could have. But even if they said he did and decided they weren't truthful, they still have to connect the dots between that and the damages. And we don't know specifically where the jury did not follow along with plaintiff from start to finish. We just know that they didn't. Plaintiff asserts essentially that you add 5 more unsavory statements and that path has just parted like the Red Sea. That's not the case. There were so many problems with plaintiff's case that I could give you, I honestly think that every one of those was a sufficient reason for the jury not to find in favor of plaintiff on their affirmative claims. The other issue that was not raised in their oral argument, but it was raised in the brief, so I'll touch on it briefly. All of the granting of the motions for summary judgment was this is bucket number 3. There was one essential claim in our motion for summary judgment. Discovery's closed. You have essential elements of these claims you simply haven't given any evidence of. You haven't given a doctor's report to say that his degenerative condition is tied to emotional distress, and you have an obligation to do so, and you haven't done so. But you can't do so now because Discovery's been closed for months and months and months, and the judge said, you're right. Discovery's closed. You cannot put any more evidence in on any of these issues, and because you have failed to meet critical, essential elements of each of these claims, you're not going to be able to proceed in front of the jury on them. So the motions for summary judgment were absolutely correct.
What about the conversion claim? It's not a lot of money, but what more could, I mean, you know, Dr. Harding said, I had this equipment, Dr. Sternsher was there, Dr. Sternsher left, the equipment's no longer there. Isn't that circumstantial evidence that
they never
walked off with the equipment?
I'm sorry, I didn't mean to interrupt. They never even provided a list of the things that were allegedly taken. Never. Until after my motion. I filed my motion and I said, you haven't even alleged what your damages are because you haven't laid out any specific thing that was taken, much less a dollar amount. Never disclosed. And then in response, suddenly there's this list of things that they put together at the last minute suddenly. But the discovery had already been closed. So, yeah, that's an essential element. I think proving damages and showing what you contend was taken is an absolutely essential element of their claim that they failed to do before the end of discovery.
But, forgive me, I noted that you did not move to strike the declaration of Dr. Harding, and my recollection is that it appeared that the court considered his declaration. So it was in evidence for purposes of the motion practice.
Actually, it was an exhibit, and so to his declaration, I don't think it was.
Right. Yeah. Yeah.
And so I think therefore it's a separate exhibit, and even if the court considered it, there were other problems with their conversion claim. Essentially, their allegation was he was there and things went missing. Well, but there were dozens and dozens and dozens of other people. There's absolutely nothing further to make any connection to, and they never even tried. I mean, that was the extent of their pleading.
I'm sorry, didn't it go a little further? The declaration said something to the effect of, I did inventories, and I think it's at a weekly basis, and I timed the missing crowns to when your client was there?
Again, long after discovery, but yes.
Well, isn't that good enough? I mean, it's not direct evidence, but it's circumstantial evidence.
Again, I have a problem with this being introduced at the first time at that stage and documentary evidence.
You didn't move to strike. I mean, without a motion to strike, and the court appears to have considered it, doesn't that create a disputed issue of fact for purposes of summary judgment?
Your Honor, I'm not certain, but I believe that I orally moved to exclude that evidence because it was grossly untimely.
Do we have the transcript of that hearing?
I'm not sure that we do.
Well, if we don't, that's not anything that we can consider. And therefore, going back, let's assume for the moment that we don't have the transcript, so that fact doesn't exist. I'm not saying you didn't make it, I'm just saying we can't consider it. Therefore, on the state of the record that we have, isn't there a disputed issue of fact on conversion?
I would argue that even if I did not file this, and I'm not sure, I cannot remember specifically the case law on this particular issue, but I believe that I did specifically object to his declaration and the evidence in my reply, and therefore while I did not file a separate motion, I did specifically object to the introduction of that evidence.
Okay, we'll take a look.
And then the last issue is the jury verdict in favor of my client on the breach of contract claim. Appellants to date have basically said nothing more than there was no written contract, and so you they can't win. And I'm not sure what that argument is, because oral contracts are plainly enforceable. My client had more than just an oral argument, had a piece of paper with the list of the materials that he had testified was repeatedly presented to Dr. Harding prior to his date of termination. That supports the oral contract. So there's obviously evidence on the record to support the jury verdict in that regard, and they found in favor of my client. And it's important because the appellant's briefing suggests almost that this was the court's ruling and not a jury verdict, but that was actually a jury verdict in my client's favor.
Further questions? Thank you.
Thank you very much.
Counsel? 50 seconds. Do you want to use them?
Yes, Your Honor. Judge Polk, you mentioned it, and you hit it right on the nose. The audio reflects the exuberance and the intent and the malice of Dr. Sternsher. You can't get that from a few pages of cross-examination. The tapes reveal that Sternsher did not believe the abuse by the plaintiff. So you remember in the transcript of the trial court, he's saying, my client did this and did that, but in the transcript of the audios, he says he didn't believe the abuse by the plaintiff. He said that he knew he was lying and admits it on the tape. He denied submitting post and anonymous letters at trial, but he alluded to those postings in the tapes. There are so many things in the tapes that really show the malice and the intent, that it's not just 15 or 12 or 13 excerpts. You need to hear even 15 minutes of the tape, and you would understand the exuberance and how excited he was to do, to put my client out of business, to do Medicaid fraud. And the tape recordings were before the dental board complaint.
Counsel, let me ask you a hypothetical. Let's say that Dr. Sternsher testified and was very direct and said, yep, I hate Dr. Harding. I hate him for whatever reason you want to make up. He maybe doesn't even give a reason. I will do everything in my power to see that he is ruined. And that was my goal. At that point, do we really need to have those recordings admitted? Doesn't it become an uncontested fact at that point?
Absolutely, because the tapes show that the trial transcript shows that Dr. Sternsher is telling the truth, that my client actually did abuse the kids. Okay? The transcripts of the recording show that he knew that was a lie. So just because he makes a statement that, yeah, I hate Dr. Harding and I want to put him away, is that enough for the jury to conclude that there is malice? No, it's not enough, Your Honor. I think my time is up.
Thank you.
Thank you. Thank you for your time.
Thank you to both of you for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.